Annual Competition Law Conference. I would also like to welcome and thank honorable members Dr. Sangeeta Verma and Shri Bhagwant Singh Bishnoi, advisors Madam Jyoti Jingar Benot, Madam Payal Malik, and Dr. Sanjay Kumar Pandey. Also, senior officials from the Commission, including Mr. Mukul Sharma and Mr. Anand Vikas Mishra from the Advocacy Division, who have been of great help and support in organizing this conference, and all the esteemed speakers and participants and friends from the media. Chairman, sir, thank you very much for your presence today in the inaugural session. As you are kindly aware, this is the 8th year in a row CIA and Competition Commission of India are organizing the annual conference on competition law. We have eminent speakers confirmed during the 2 days conference, deliberating on 4 technical sessions. We also have more than 700 people participating in this virtual conference today. I would also like to take this opportunity to thank and acknowledge on behalf of CII that the enforcement of the Competition Act and the establishment of the Competition Commission of India have helped set up a robust legal framework so necessary for the economic development of the country. CII engages closely with the Commission in evolving the competition law in India and for the advocacy initiative. As a proponent of healthy competition, CII has all along maintained that while there should be regulation of market fair play, the legal framework should not impede the steady growth of the economy, as competition is not an end in itself, but a means to achieve larger economic goals. CII works to create and sustain an environment conducive to the development of India, partnering industry, government, and civil society through advisory and consultative processes. We have, over the years, together with the Commission, organized number of interactions and sessions with industry members across sectors to help advocate the importance of complying with the competition law. These platforms enable open dialogue between the regulator and the regulated to ensure that the industry grows and evolves in the country to be at par with the global standards, while of course facilitating the growth of business and economy. While encouraging competition compliance by the industry at CI, we have been taking proactive steps for ensuring compliance with the competition laws. The Competition Act applies to decisions, rules, recommendations, and other activities carried on by associations of enterprises, including trade associations like ours, whether it is membership rules, meetings and discussions, or compilation of statistics. We are making sure that members follow the do's and don'ts in true letter and spirit and to be on the right side of the law. Well, I will not take much time and would like to conclude that as we are conscious of the fact that the workings of the Commission and competition law need to be in harmony with the evolving business environment and in an Indian economy, the Competition Commission of India, under your leadership, sir, has indeed played a very significant role to ensure fair and healthy competition and economic activities for faster and inclusive growth. With these remarks, I welcome you all and once again thank the Competition Commission of India for all the support, and now hand over to Dr. Lalit Bhasin, Chairman CI Task Force on Legal Services, President Society of Indian Law Firms, and partner Bhasin and Co. for his introductory remarks and for moderating the session, please. Thank you very much.
Thank you, Mr. Vikas Mohan. I welcome the Chairman of the Competition Commission of India, Shri Ashok Kumar Gupta, my illustrious colleague in the profession and Chairperson of CII National Committee on Regulatory Affairs, Zia Mody, Mr. Sidharth Sharma, General Counsel Tata Sons, Mr. Vikas Mohan, Executive Director of CII, Dr. Sanjay, all the participants and officers of the Competition Commission of India. I will be very brief. The chairperson of this CII National Committee on Regulatory Affairs, that is Ms. Zia Mody, he has to join a remembrance meeting in the memory of her late father, but who belonged to all of us, that is Soli Sorabji, which has been organized and hosted by the Supreme Court at about 10:30 a.m. Soli, as we all used to fondly call him, he was an illustrious leader of the Indian Bar, the Attorney General of India, and above all, a great human being. So I have the privilege of chairing this session in the absence of Ms. Zia Modi, who will share her thoughts with us, and then she has to leave for the meeting in the Supreme Court in the memory of our dear Soli Sorabji. Uh, I would like to take this opportunity of just pointing out that the predecessor act of the present law, that is the MRTP Act, was described by the Supreme Court itself as the most ill-drafted piece of legislation that the Supreme Court had come across. These are the observations of the Supreme Court. And that act did not serve any purpose at all because, as the very name suggests, it was restrictive in nature. Monopolies and Restrictive Trade Practices Act, you see. Therefore, it was in the wisdom of the legislature that the new act was brought in, which encourages and promotes good and healthy competition. And it is an evolving jurisprudence. And who could be a better speaker than the chairperson to address us, to give the keynote address than Shri Kumar Gupta? During the course of the 2 days conference, we the participants would be discussing the competition law, that is the journey, learnings and the way, and then evolving paradigms of competition law, as also mergers and acquisitions, and emerging issues in antitrust enforcement and online markets and e-commerce. These are very important and vital subjects. And just before the event, uh, Ms. Zia Modi was sharing with me that how much work you see this competition commission has done, that it is remarkable, and the work is now recognized. So with these few introductory remarks, I would now request the chairperson of CII National Committee on Regulatory Affairs, Ms. Zia Modi, to please share her views with us. Thank you. Over to you, Zia.
Thank you very much, Lalit. Much appreciated. I do apologize for leaving early, but I think that the full court reference of the Supreme Court will have my father present there and smiling. And I want to be sure that we are smiling with him as a family. So please excuse me and my apologies. Thank you so much, Mr. Ashok Kumar Gupta, for joining us today. It's really a pleasure for us to have you take the time to address the industry. And on behalf of CII, we are indeed very, very grateful. Thank you also for all the members of the Commission, Dr. Pandey, and all the participants who are obviously here to listen, not to me, but to the chairperson. I'll just give you some thoughts initially just to get the ball rolling. So, we are hopefully getting over the trauma of COVID. We've adapted, we've responded, we've been vaccinated, hopefully, and life is now moving on to a more normal state of affairs. But in the 1.5 years, as far as CCI was concerned, I think we were very, very pleased and grateful to see how CCI, even though members were not well, there were so many hurdles that the CCI faced internally, just in terms of COVID and other calamities. We were quite comfortable that approaching CCI would still make sure that the uncertainties would be addressed and that the proactiveness to react during the pandemic and allow the merger control review of transactions and guidance continued. So thank you very much to the Commission. Let me just touch on three topics very quickly, since these are what is the subject matter of the opening session. One is to see how CCI has been an enabler of the ease of doing business. Now, here, what is ensuring the ease of doing business? Getting things done productively, proactively, correctly, and in a reasonably quick time. Here we have, even with officers working from home, people who were affected in the second wave, everybody in the commission has really come forth and helped. Physical filings were replaced with e-filings, physical meetings were replaced with basically virtual ones. And where we are today, if you want statistics, is that the Green Channel has proved, Mr. Chairperson, a resounding success. The industry is very, very pleased with the fact that there has been, as of November end, 44 transactions which have gone through the Green Channel since it started in August 2019. That is a good number, and we continue to advise our clients that if we are convinced that the Green Channel is good to go, the Competition Commission, with a sensible discussion with us, often basically gives us the go ahead and life continues smoothly. There were around 85 other combinations which were approved in 2021 as of 30th November. These were quite complicated, some of them. If you look at the renewable energy one of Total Adani, the Tata digital one in Big Basket, you had Zomato and Grofers, just to give you some sense. You had the life, so HDFC Exide. So in every sector, we've been seeing the commission come forth and play a very productive role and allow business to go ahead. I think generally the audience will also agree that the decisional practice over the last few years of the CCI has increased certainty for practitioners, for intermediaries, and for business. If you look at the applicability of exemptions, you are getting the framework of where the CCI would get comfortable. If you look at the way the CCI has started assessing business overlaps, that again, through jurisprudence, is getting to be clearer and clearer. And as I said, the Green Channel. Our team believes that the pre-filing consultations have really become very productive and give a lot of comfort so that we know exactly which is the route to take, what steps to take, and the feedback has generally been very positive. So thank you. On the issue of penalties, what every business dreads to hear about. Again, I think in COVID, we've seen that the CCI has adopted a very calibrated approach in its enforcement decisions. They've understood the concerns that businesses have gone through during pandemic, when some paper manufacturers had issues under the CCI Act. The CCI consciously levied a lower penalty, understanding that the paper industry had been significantly affected because businesses had moved to a virtual mode, the need for paper had reduced, and the CCI order in fact records that any significant penalty would have rendered these people unviable economically. Similarly, when it comes to MSMEs, and a practical approach is taken, given that there is a balance to be drawn between enforcement and business survival in these unprecedented times. So even recognizing the ground realities is something that this regulatory authority has clearly recognized. The other thing that has proved, I think, very heartening to the business community is the steps and initiatives that you have taken to understand the various industries and the sector specific issues. So here we've again seen the CCI being proactive. You look at the comprehensive report on the e-commerce sector. You've looked at the recently published market studies for the pharmaceutical sector, the telecom sector. This again allows business to look at it and see the transparent way the CCI is thinking, putting its thoughts on the table, and taking things back internally when assessing behavior and when assessing M&A. We are, as we understand from last year's discussion, you are conducting a market study in relation to private equity investments and issues relating to common ownership. This is, of course, important, and I know it's dear to the chairperson's heart. He's focused on the PE issues. But, we are anxiously hoping that the engine of M&A activity of PE is looked at thoughtfully, purposefully, and full consultation is clearly the order of the day. Again, the widespread use of block technology globally has resulted in the CCI publishing a discussion paper concerning this. And when you look at the way everything is heading towards digital, the global economy, and new age technologies, it's clear that CCI is not going to be left behind in the thought process that it goes through. We were talking before you joined, Mr. Chairman, about the new Chennai office that you have started. And I was very pleased to hear Dr. Pandey say that Bombay is on the anvil. Otherwise, I was going to make a public plea that you don't forget all of us in Bombay and that you do set up an office as soon as possible here, please. I believe Calcutta is also on your priority list. Next thing is the learnings and the rich jurisprudence. When we started in 2009, I remember I had flown to Delhi. The first chairperson, Dhanendra Kumar, was there, and we were grappling with how to really make sure that the combinations regulations didn't stop M&A activity, seen as a progressive move, because it was a real change of law, of process, of thinking, actually. And from there, you can see just how far we have come. The sectors that we have dealt with as the Commission: entertainment, pharma, aviation, agriculture, construction, cement, sports, real estate. So apart from the traditional economy sectors, the new economy is in full play before the Commission. The incentive to innovate has been recognized as having to be balanced with anti-competitive practices. The sandboxes that are happening, the unicorns that we have produced. I was given a data point a few days ago that India has produced more unicorns in this year than in the last 15 years put together. And that says something absolutely great about our economy. And I'm sure the Commission is minded to facilitate it. The advocacy efforts that are going on are also significant. I think the data that I have is that CCI has conducted 750 advocacy events till date. And in March 2021, the CCI organized the 6th National Conference on Economics of Competition Law. I understand, again, Mr. Chairperson, it's an initiative that the Commission has taken to focus on a strong focus on public procurement. And that again becomes important with your diagnostic toolkit, where this has been folded into what you expect to avoid anti-competitive behavior. And as I understand, you've got the state resource pension scheme. So resources are trained in each state for training the PSU procurement officials, equipping them with competitive tender design tools, and assisting them with competition assessment of bids and tender outcomes. Once again, focus on data privacy concerns. One cannot just avoid that this is here to stay. And when data is considered the new oil, therefore it has to be regulated appropriately as well. Again, here the striking of the balance between addressing market distortions without stunning efficiency and innovation is something that I'm sure the Commission is fully tasked with. And we continue to expect their complete support and a pragmatic approach. We saw that when there was a order passed by the CCI issuing the non-contravention orders pertaining to certain complaints on new age markets, Everybody received that very gratefully and was very appreciative of the same. The leniency framework, I think, continues to settle, and it is being used responsibly. It has been successful, and also we've been seeing that the evidentiary standard, which has come forth in leniency applications, is now settling in. And where evidence has not been sufficient, we have seen the Commission boldly state that this was not enough to establish cartel conduct. Now we go to the last topic from my point of view, which is the vision for India at 75. What's very heartening for me as a lawyer is to see how the normal orders where we saw the CCI's orders being set aside for violation of the principles of natural justice has reduced significantly. A proper hearing, a considered approach, a thoughtful outcome, and a reasoned order is now expected in almost every situation. The fact that the CCI is now cooperating with other regulators is putting it on the world map with all the other serious and credible regulators globally. And this is going to only continue. We've seen the recent cooperation with the Japan Fair Trade Commission, and I'm sure that interaction globally between regulators can only help our economy and the approach that you take and that you bring forth to the industry. The one request, sir, is whether we could ask the Commission to let us benefit from more guidance notes. I know that in the beginning, when I used to plead for guidance notes, the chairperson used to tell me, Zia, wait, Zia, wait. May I now once again request our chairperson to let us have more guidance notes, especially in the area of dawn raids, especially in the area of how you would expect various issues on enforcement of merger control aspects. Dawn raids, I think, is critical. It is the need of the hour. And guidance notes would only help not only us, but also you, because we would obviously take it seriously and want to comply. The new amendment bill of 2020 is certainly going to provide greater tools for better justice delivery. The concept of settlement and commitments, the upfront proactive proposed advance ruling mechanism. I think this is everything that allows a sensible discussion, cooperation will only lead to better behavior. That is obvious. And therefore, the more we can engage with the Commission as a partnership, the more we will hopefully make your load lighter, sir. The latest proposed amendments where you have invited stakeholder comments on the confidentiality regime is indeed very heartening, and we look forward to engagement on that. The basis on how you want to have confidentiality rings so that the party on the other side knows what is there which it has to defend is again going to deepen your jurisprudence and promote and ensure a fair competition regime. So I think I've taken my time, Vikas, and I think I want to conclude, Mr. Chairperson, and all the CCI members to thank you for the efforts that you continue to make to strike the right balance between maintaining fair and effective competition in the market and to maximize the ease of doing business in a difficult phase. We express the hope and we are sure that this trend will continue. And so with the advent of path-breaking new technologies, artificial intelligence, data privacy, we are waiting to see how we progress together in these uncharted territories. We only think that this is going to be an opportunity, Mr. Chairperson, for developing regulators such as CCI and for us as intermediaries and the business community to shine and partner together. So thank you very much for this opportunity. I very much appreciate it and wish you all the very best.
Thank you, Zia, for taking us through the journey. That is the learnings and the way forward. I think, actually, no, Zia, but possibly some of you may not be knowing that she is widely acknowledged for her expertise and ranking number one in Fortune India's 50 most powerful women in business list in 2018 and 19, on which she has consistently ranked in the top 10 since 2011. According to the RSG India report, clients praise Zia as a problem solver who is meticulous, thorough, and accessible and comes highly recommended for any complex legal matter. So thanks for your brilliant address, the overview, and the way forward. So thank you very much for joining us, and
Thank you.
thank you.
Thank you.
So now I have great pleasure in having again one of the stalwarts in the profession, although he's employed by Tata Son, but I consider him as a professional colleague because of his background. That is Mr. Sidharth Sharma. He's the General Counsel Tata Sons. He's got about over 16 years of experience. He currently serves as the General Counsel and he heads the group legal department. Prior to the current role, Sidharth was a counsel for Tata Group and acted as their resident counsel in Delhi. Sidharth is I call him a colleague in the profession because he's also got the distinction of being an advocate on record in the Supreme Court of India and appeared very frequently in the civil appeals in the Supreme Court. In the past, Sidharth has associated and assisted the industry by his participation in chambers like CII, FICCI, and Bombay Chamber of Commerce on legal advocacy work and in making representations to the government on a variety of legal issues, particularly on competition law. So it is befitting that we have an address by Mr. Sidharth Sharma, and I have great pleasure in requesting him to please share his address with us. Over to you, Mr. Sidharth Sharma.
Thank you, Mr. Bhasin, for that kind introduction. I think much of that I don't deserve, but thank you for those kind words. And thank you all for having me today for this as part of this inaugural session for this conference. And it's really truly an honor for me to share this panel along with the Honorable Chairman of the Commission and other members of the Commission and senior members from the profession. So thank you. I would also like to convey my regards to those who are in the audience, members and officials of the Commission and others, most of whom would be senior to me in both age and experience. So please accept my regards. I'm also I must say that these conferences are very useful and important for the reason that when we interact with the Commission, mostly on a regular basis, our interaction is basically on what the law is. We debate with the Commission what the law is. These conferences give us an opportunity to also discuss what the law should be. So it's really a very useful opportunity for me personally to be participating in this conference today. On competition law and its implementation, I think it will be a cliche to say that we have come a long way. I still remember which I was discussing with Mr. Bhasin and Zia before the session started, that in 2008, when I was very junior in the profession and I was assisting some of the industry chambers on competition law and making representation to the government on its implementation, because it was the initial phase of implementation. And industry had concerns, especially on merger control, because the way thresholds were defined in the Act, it appeared as if anything and everything will be notifiable. And coupled with that, we had this 210 days of waiting period before a transaction could be concluded. So there were concerns, but we have really come a long way. And I think the credit entirely goes to the Commission, because they have been very, very proactive, understanding, and practical, I would say, in addressing industry concerns, both insofar as practice of competition law is concerned. So, Commission has addressed most of those issues through its regulations. It has addressed the gaps in the law, or what we say the silences in the law, through regulations, through clarificatory notifications. So they have been very useful. And today we have a very robust merger control regime in the country. It is, I think, I don't need to say it, but today CCI is the most prominent and recognized, well-recognized regulators, not only in India, but globally. And this is a big achievement because I know, and everybody knows, that while we often compare ourselves with UK, US, and all these advanced jurisdictions, the resources with which our regulators, and in comparison of, if we compare with regulators in other countries, the resources with which CCI functions, given that, I think the work CCI has done is really, really remarkable. And I most humbly congratulate you for that. Also, CCI has been careful not to be, again, the initial concern was, if I may say, that would CCI become another MRTP commission, or will it become a trigger-happy regulator? That has not happened. CCI has been very selective in its intervention. And even in merger control, most transactions get approved and within the timelines. So that is another area where CCI has been doing what it was expected to do. Now, coming to the topic for discussion today, and I'll just touch upon a few points, because Zia has addressed well. And now, as a practitioner, and now that I am part of a big conglomerate, these are just suggestions, and I speak about them as a student of law rather than industry representative. So on merger control, CCI has in Schedule 1, CCI has tried to filter many of these transactions which do not raise competition law concerns. And one such transaction is when acquisition of less than 25% take place and they don't result in acquisition of control, then, or if the acquisition is in ordinary course of business, then they are subject to Form 1. Now, there, while this is a filter and this is the intent of the commission, in practice what is happening is that acquisition of less than 10% in a competitor is still getting covered. I think in practice, lawyers are taking a view that if you are acquiring less than 10% in a competitor, then it may not be treated as acquisition in ordinary course of business. And that is an area of because ultimately in merger control, the analysis is largely about testing the overlap when two enterprises are merging. Now, there currently the threshold is quite low, and if it is all investments above 10% get all entities in which the merging enterprise has more than 10% gets covered. If it is less than 10%, then there are certain additional tests. This I say from the perspective of a conglomerate, because I represent a conglomerate. This threshold is very low, and while assessing overlaps, then it becomes a very cumbersome exercise, especially for conglomerates. So it is again a request and a suggestion that if for assessing overlaps, if threshold could be a little higher, again the control test or something similar which we have elsewhere in the regulation. Third point, and it's a small point, and this is a vested interest point, the definition of group. Now in the Act, definition of group follows the test of 26% shareholding, but through a notification it was increased to 50%. That notification has lapsed, and I understand that the same understanding continues, but at some point I would expect that the Commission would clarify it formally, so that the threshold to determine group remains what it has been. The next point would be what Zia emphasized, and I would second that, that if we can get more guidance notes from the Commission. I know guidance note, it's a double-edged sword, because on one hand, the jurisprudence has to develop, each case has to be decided on its own merits. But now that Commission has enforced the law for over a decade, I think more and more guidance notes, not only on merger control, but also, sir, on vertical agreements. What are the red lines that Commission would say enterprises cannot cross? How would you view an exclusivity clause in an agreement? So that sometimes what happens is, it's not that enterprises are trying to breach the competition law. What happens is that while drafting agreements, the business realities and also the practical considerations lead to Am I audible, sir? I lost the connection for a while.
Yeah, you are. We are losing you in between, but
Okay.
please continue.
So I was saying that these guidance notes will be quite useful from industry perspective. It would also reduce the gray areas and number of complaints that Commission gets or may get in the future. If we have guidance, the parties can take corrective steps at the time of getting into those agreements. Another point which Zia mentioned, and I fully second that, which was also part of the Competition Law Review Committee's recommendation, which is on settlement and commitments. So rather than going through the whole rigmarole of proceedings, if there are issues with a particular agreement, and if enterprises are willing to address those and make commitments that they will not, or they will take corrective steps, then a formal mechanism for settlement and commitments, as suggested in the review committee report, would also be, I feel, a welcome step. Next point, and sir, I'll be very curious to know as a student of law, again, is about the whole piece about green channeling some of the transactions. Now, and I speak, I'll take 2 minutes to speak purely as a student of law. Don't treat me as a representative of a particular company. In the review committee's recommendation, there were suggestions about green channeling certain transactions, including enterprises which are in insolvency proceedings, acquisition, which are into IBC section, but of course that has not been implemented. And I'll be very curious to know that what the Commission's thought process is, because under IBC, I think there is a tussle. So the committee of creditors who have to get money, they would expect as large an offer from the resolution applicants as possible, because if it is low, they have to take a haircut, right? So COCs object is to get as large an offer as possible. Now, who can make a large offer for an IBC enterprise which is into insolvency? Only another enterprise which is in the same field. So, say if it is the if
I think we are losing Mr. Sharma in between.
gives to consist dominant. Sorry, can I go ahead?
Yeah, now your voice is clear. If you may conclude, summarize your address, and then we can move to the next speaker, please.
Yes, yes. So this was one point that how IBC cases are being considered for green channeling. That was one point. And then just 2 points, and I'll finish. One is how has been the experience, because I don't have data points, but I can speak of from anecdotal experience. Since compact was done away with, all the appeals are going to NCLAT, and NCLAT already has other jurisdiction, company law jurisdiction and IBC jurisdiction. So would it be correct to guess that competition law cases are getting slowed down before NCLAT, because NCLAT is already burdened with other types of cases? Because ultimately the jurisprudence to develop, the tribunal will play an important role. So anecdotally, I feel that perhaps competition law cases are hitting a bottleneck in NCLAT, and what would be, if there are any thoughts on that to address that? And lastly, I would just say that there are some issues which are sub judice. I will not speak about them, but guidance on penalty and the mix of members who would perform adjudicatory function. Of course, courts will decide, but I just again, one thing is to say that you must have this thing is that or it has. So that will be another suggestion from my side, that on imposition of penalty and also in terms of adjudicatory function of the commission, I think there are certain suggestions which are already known to you, and that those could be considered. With these suggestions, I will conclude my address, and I once again thank all of you for giving me this opportunity to speak today in this session. Thank you very much.
Thank you, Mr. Sharma. I think you raised very important issues. You started with raising that earlier people had concerns on mergers and controls, but how you see the Competition Commission of India has now dealt with that and made it a smooth process. You have also highlighted that our experience is that the Competition Commission of India is not a trigger happy regulator. It is a coordinator, a supporter of the economic development of this country. You also suggested that there should be a clarification on the definition of group, and then about settlements and commitments and about penalties. One point where I definitely agree with you is about the role of the appellate body, that is NCLAT. I think it needs to be, there needs to be a separation of competition cases from NCLAT. NCLAT is burdened not only with company law matters, but also with IBC. Therefore, I think it is a body which cannot deliver the goods it is meant to be established for, either in the case of Companies Act or in case of competition law or under IBC. Therefore, I think that the ministry needs to have a look at it. I can see that you will continue to get inspiration from that photograph of one of the greatest lawyers of the country, Nani Palkiwala, who is in the background.
Yes, sir.
I think He will continue to guide you in your endeavors in Tata Sons. I have had the privilege of working with him, assisting him, appearing with him, opposing him. He was in the Supreme Court here. So it's very good to have you, Mr. Sidharth Sharma. And now that is the fitting finale to this inaugural session, that we have none other than the chairperson of the Competition Commission of India, Shri Ashok Kumar Gupta. Shri Gupta is heading this competition commission at a very crucial and relevant time. He is a 1981 batch IAS officer of the Tamil Nadu cadre. He has had an illustrious career of 40 years in public service spanning across sectors from industry, finance, health to defense production. He is currently serving as chairman, of course, of the Competition Commission of India, but holding the additional charge of the chairperson of National Financial Reporting Authority, that is the NFRA. So I have great pleasure in introducing to the participants and handing over the uh, uh, the proceedings to Mr. Ashok Kumar Gupta, our chief guest today, to please deliver his keynote address. Over to you, Vardi Shri Gupta. Thank you.
Thank you, Dr. Lalit Bhasin. Ms. Zia Mody, Chairperson, CII National Committee on Regulatory Affairs and co-founder and managing partner, AZB and Partners. Mr. Sidharth Sharma, General Counsel, Tata Sons Private Limited. Dr. Lalit Bhasin, Chairman, CII Task Force on Legal Services, President, Society of Indian Law Firms, and Managing Partner, Bhasin and Company. Mr. Vikas Mohan, ED, CII, session moderators, distinguished panelists, participants, my colleagues and officers. A very good morning to all of you. It gives me immense pleasure to be with you, albeit virtually, in the inaugural session of CII's annual conference on competition law and practice, which has now been institutionalized as a flagship event and is an outcome of the joint efforts of CII and CCI. This is an opportune time to reflect on the enforcement journey of CCI and to take stock of the experience gained and challenges overcome during the last 12 years in enforcing and evolving the competition law framework. This journey could not have been smooth without the constant and valuable feedback of stakeholders, including industry associations and the cooperation of competition law practitioners. It is extremely important for any regulator, more so for a market regulator, to have a healthy dialogue with stakeholders so as to have an enhanced vision of market realities and better outreach. Conferences like the present one play a pivotal role in providing an opportunity for robust and frank exchange of insights on various issues between stakeholders, and I must convey my compliments to CII for structuring this conference such that it covers virtually all aspects and facets of competition law enforcement. This would help steer discussions in the right direction. Emergence of new age economy has brought the roles discharged by antitrust agencies to center stage, which were otherwise busy dealing with conventional markets and monopolies operating therein. This has reinforced the relevance and significance of competition authorities in regulating digital markets within the overarching regulatory ecosystem. It's a matter of satisfaction that CCI has been able to rise to the occasion by dynamically responding to new age challenges, even as it built its capacities along the way and while on the job. The expert panel, that is the Competition Law Review Committee, that examined and reviewed the legal framework, found the statutory architecture to be robust. The interventions made by CCI testify to the adequacy and flexibility of the law in applying the existing law to the new age economy. In the last 2 years, CCI also had to brace itself while dealing with and addressing the challenges posed by the global pandemic. Apart from taking steps to keep it functioning unhindered and accessible to stakeholders, CCI also contributed to economic recovery by facilitating inorganic growth through faster clearances and approvals of M&A cases. As we emerge out of the global pandemic, CCI has to adopt and apply a nuanced approach that not only addresses market distortions in a targeted and proportionate manner, but also contributes to economic recovery. With these overarching challenges and goals, let me share some snapshots from the decade-long journey of CCI as a market regulator, the difficulties and challenges we faced, and the way forward. 12 years ago, the substantive provisions of the Competition Act 2002 relating to anti-competitive conduct were notified, marking a watershed in the regulatory governance of the Indian economy, which was transitioning to an economy where markets were essential instruments for resource allocation. Competition is the life force of markets and creates the best incentive for businesses to increase efficiency, drives their productivity, and fuels innovation. Despite its all encompassing benefits, healthy competition may not emerge on its own. Even the most ardent votaries of a market economy recognize that liberalized markets cannot be presumed to be competitive and efficient. Without oversight and necessary intervention, we could witness a chaotic environment where cartels drive up prices, dominant firms misuse their market power to fence out competition, or anti competitive mergers weaken the competitive structure of markets, resulting in businesses being affected and consumers being deprived of value for money. Such distortions break the link between liberalized markets and the productivity and innovation gains they are believed to yield. Therefore, the need for regulatory oversight cannot be overemphasized. CCI, established as the enforcer of competition law in India, devoted its formative years to shaping the regime in accordance with evolving market realities while anchoring it in the economic development goals of the nation. The focal points of its actions and interventions have been to bring about swift market correction so that businesses can compete on merits irrespective of their size, and most importantly, ensure that consumers benefit from improved market outcomes. Since its inception, the Commission has examined more than 1100 cases of anti-competitive agreements and abuse of dominant position in diverse sectors of the economy such as airlines, banking, capital markets, e-commerce and digital markets, infrastructure, travel, automobile, real estate, pharmaceuticals, financial sector, publishing, manufacturing, mining and entertainment. The instrument of enforcement has been applied judiciously, keeping in mind the specificities of the sector involved, market structure and nature of interventions. In correcting market distorting practices, the Commission has used an effective mix of the twin instruments of enforcement and advocacy. The instrument of enforcement has been applied in a calibrated manner with interventions made only in such cases where business conduct was found to seriously undermine market processes and mute competition. While dealing with cartels firmly, CCI has been cognizant of business realities and molded its remedies appropriately. The Commission has incentivized self-reporting and offered businesses the opportunity to approach the Commission for lesser penalty by making vital disclosures on cartels. The idea has been to engage the industry not only for prompt detection and rectification of competition problems, but also to make them realize that everyone stands to gain from fair and competitive markets. In recent years, digital markets have been the focus area of competition agencies across the world. Technology and disruptive innovations in the digital economy are continually altering the contours of markets, transforming the ways of doing business, ways of communication, and ways of transactions. While on one hand, digital incursions foster competition by creating more opportunities, bringing transparency to online intermediation, and reducing cost for consumers. On the other hand, The increasingly technology-laden economy is bringing new issues and concerns to competition policy discourse. There has been a steady rise in cases reviewed by CCI emanating from new age markets, which range from across the verticals such as search engines, online marketplace platforms, app stores, payment gateways, online travel, food aggregators, cab aggregators, and social networking. Such cases involving search bias, predatory pricing, deep discounting, self-preferencing, and leveraging have a direct interface with competition law regime. The Commission's role in such cases is to ensure that platforms, which act as a central point for interaction between different sides in digital markets, remain neutral, offer a level playing field, and allow enterprises, big or small, to compete on merit. Merger control in digital markets also presents some unique challenges. With increasing number of acquisitions and investments, large platforms are rapidly expanding the scope of their business interests with the possible motivation of collecting complementary data that help reinforce their market position. Data is a crucial factor for economic power and for judging market power on the internet. An important issue is how to account for data in a merger assessment. Since not all digital markets are alike, nor is all data, interventions in merger reviews in technology markets need to be guided by case specific economic evidence of competition concerns. In these fast evolving and dynamic markets, the regulatory stance needs to be nuanced and the enforcement toolbox needs to be adapted to these changes so that the instrumentality remains fit for purpose. The challenge is to keep abreast of the developments in these markets and continue to evolve and refine the tools. This will help make timely interventions and strike a fine balance so that efficiency and innovation are not stifled and markets remain free from anti competitive practices. CCI has also been continuously streamlining processes and procedures to meet the demands of the times. Presently, CCI is in the process of introducing a confidentiality regime in line with the best global practices in consultation with stakeholders. As I mentioned previously, the last 2 years have been very challenging for almost all sectors and economies across the world. While the pandemic has obvious health implications, it has also given rise to serious economic consequences. The lockdowns of various degrees that have been in place from time to time to flatten the curve of rising COVID-19 infections resulted in unprecedented disruptions to the normal course of economic activities. CCI, however, rose to the occasion and took several measures to meet the regulatory challenges posed by the pandemic. To this end, CCI leveraged technological tools to ensure that competition regulation continues uninterrupted. Let me briefly touch upon some such initiatives to cope with significant changes in supply and demand patterns arising out of this extraordinary situation. CCI issued an advisory as early as April 2020 for the guidance of stakeholders. This enabled businesses to take swift commercial decisions without unduly worrying about regulatory actions. During the national lockdown, CCI proactively initiated a system of electronic filing and digital payment of fees. For the benefit of all stakeholders, dedicated helplines were set up and various guidelines issued from time to time. Furthermore, statutory and other meetings were conducted in the virtual mode and information, notices, and submissions were accepted electronically. Thus, the need for physical interaction with the Commission was nearly eliminated. Further, all proceedings with parties were seamlessly conducted by CCI through the virtual mode. On the merger control side, pre-filing consultations were facilitated through the video conferencing mode. The investigation arm, that is, Office of the Director General, adopted new, legally acceptable methodology to take digital depositions during investigations, duly maintaining the sanctity and integrity of the process. Simultaneously, CCI, being cognizant of the need and significance of inorganic growth for enterprises to attain size, scale, and efficiency, strived for faster approvals of mergers and acquisitions to promote economic recovery. From the onset of the pandemic till date, CCI has decided 140 merger filings in diverse sectors such as financial markets, pharmaceuticals and healthcare, power, and digital markets. Further, as part of its ongoing and regular efforts to make M&A filings approval faster during COVID, CCI continued to promote the automatic system of approval for combinations under Green Channel, which was introduced in August 2019. This first of its kind trust-based system in the world aims to sustain speedy, transparent, and accountable merger review, striking a balance between facilitation and enforcement and creating a culture of voluntary compliance that supports economic growth. More than 40 green channel notices have been received since introduction, with over a quarter of the transactions being filed under this route, demonstrating stakeholders' confidence. CCI also took several initiatives to ease compliance burden by constantly and dynamically reviewing its processes to make them market friendly. For instance, CCI amended the merger control regulations to dispense with the requirement of providing information on non compete arrangements in merger filings. Further, revised guidance notes were issued, which gives parties to the combination clarification notes on the information to be filed with CCI. Further, during the pandemic, CCI continued with its practice of complementing enforcement efforts by conducting market studies. At the beginning of the last year, CCI completed a market study on e-commerce that was undertaken to develop a better understanding of the novel competition issues emerging with the growing importance of digital platform-centric commerce. Market studies in the telecom and pharmaceutical sector were concluded this year. The telecom study brought out new issues and challenges from the competition law perspective, with the market moving towards data-based applications and services and technology-led convergence across the value chain. Competition concerns arising out of data were flagged, and it was highlighted that the antitrust law framework is broad enough to address the exploitative and exclusionary behavior arising out of privacy standards and entities commanding market power. The study accentuated the need for a harmonious regulatory environment focusing on strengthening cooperation among sectoral regulators and the competition authority. The farmer study aimed at identifying the regulatory and policy levers that can improve market outcomes, especially on price and quality, and harness industry government partnership for the provision of affordable medicines. With the overarching objective of understanding the competition landscape in the pharmaceutical sector in India, the study focused on specific realms of distribution architecture for drugs, including the emergence of e-pharmacies, trade margins, prevalence of branded generic drugs in India, and its implications for competition. Another important milestone during 2021 was the setting up of the first regional office of CCI to enable easy accessibility to stakeholders. On 26 February 21, CCI operationalized its first regional office at Chennai, which will cater to Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Telangana, Puducherry, and Lakshadweep. Along with strengthening advocacy outreach activities, the regional office is expected to facilitate enforcement by acting as a center for filing and receiving cases, as well as facilitating investigation, follow-up court cases, and online depositions in coordination with Delhi office. CCI is also in the process of setting up regional offices in the eastern and western regions. Before I conclude, let me also mention the advocacy initiatives undertaken by CCI in all these years, which have evolved as a non-intrusive measure highlighting a trust-based, acceptable, and inclusive competition compliance regime among stakeholders. CCI, through competition advocacy with stakeholders such as central and state governments, PSUs, industry, trade associations, professional bodies, and academia, promotes the importance of a culture of competition across sectors. The outbreak of COVID-19 posed formidable challenges in terms of effective continuance of the Commission's advocacy initiatives. However, all advocacy initiatives of the Commission not only continued unabated, but were also implemented efficiently through online modes despite the constraints posed by the pandemic. Through sustained and focused advocacy initiatives, CCI continued its efforts to ensure that procurement markets remain competitive so that public money is well spent and fiscal space is created for funding other socio-economic priorities. For greater outreach, state-level advocacy literature was translated to different regional languages. As we prepare ourselves to celebrate the 75th anniversary of Indian independence, it is only appropriate that we gear ourselves to build our capacities to address the challenges looming on the horizon. To commemorate the landmark milestone, and for a resurgent Atmanirbhar Bharat, I am confident that events such as this would help in developing a regulatory framework which will merge the best of tradition with the most modern global outlook. On this momentous occasion, as we sit on the cusp of paradigm changes in the economy, CCI would have key responsibility to discharge in helping markets evolve, keeping a firm watch on any anti-competitive conduct in the process. Ms. Zia Mody and Mr. Sidharth Sharma, they have asked CCI to come out with some guidance notes for the benefit of industry. Jurisprudence is still evolving, and our orders provide some indication of our thought process. However, wherever there are gaps, we will come out with FAQs. Also, I have noted other suggestions from the eminent panelists. With this, let me conclude by again congratulating CII for conceiving and designing this event on a theme of great topical and contemporary relevance. I am sure this would go a long way in spreading awareness about the nuances of competition law regime amongst its members. We will look forward to the deliberations and suggestions that emerge from this two-day conference, which will guide the future journey of CCI in implementing this dynamic legislation. Thank you very much.
Thank you, Honorable Shri Ashok Kumar Gupta ji, Chairperson of the Competition Commission of India. Speaking for myself, it was a great learning experience for me, even though I have put in about 60 years in the profession. But I think your address touched upon so many new aspects of the competition law as it is emerging, that it was a learning experience. Your thanks for a brilliant and profound, informative and educative address. But heartening feature is that you made us aware that the Competition Commission is aware about the and taking cognizance of the business realities. That is very crucial and important, that you are not living, you see, in a different arena, different environment. You try to absorb, you see, what are the ground realities which exist so far as the business is concerned. And as you rightly said, you are applying law to the needs of the economy. I think that is very, very educative, and that your commission has a very nuanced approach to the economic recovery. But at the same time, you emphasized, and that is very important, and I entirely agree with you, that there has to be a regulatory oversight to avoid any chaotic conditions which may come up. Therefore, regulatory oversight is very important. Then you rightly touched upon, you see, the changing contours of the economy because of the digital transformation which is taking place, not just in India, it is taking place globally. And it is heartening to note that you are putting in place a confidentiality regime that will be, I think, a great step and would benefit the business and the industry. And we are also very appreciative of the role that the Commission played during the pandemic by relaxing so many conditions, by making it easy to carry on business, you see, even during the difficult times. So on behalf of CII and on behalf of this our competition committee, I thank you profusely for sharing your very valuable thoughts with us.
Thank you very much.
I also thank Mr. Sidharth Sharma, the General Counsel, Tata Sons Limited, for sharing his practical views and also giving some practical suggestions. In absentia, I also thank Zia Mody, my colleague in the profession. And last but not the least, I thank Mr. Vikas Mohan, the Executive Director of CII, for us to put in place this very important eighth annual conference on competition law and practice. With these, I thank all the worthy panelists and also the participants for sharing with you, and but particular thanks to Shri Ashok Kumar Gupta ji. Thank you very much, sir.
Thank you very much, sir.
Thank you.
Thank you, Mr. Gupta.